For joining us today. Hello to the folks on Zoom. Please listen if you have any audio issues. My name is Sarah, and I work at the Vera Institute of Justice, which is a national research nonprofit. We'll talk about it a little bit more shortly. But my job is really to collaborate with local advocates, state justice system stakeholders like all of you, and elected officials, both on the local and state level, to really think about how to do public safety differently, right? To say what's working and what isn't working, and how can we implement best practices and blueprint models that improve justice and safety for our communities. I'm joined today by my colleague Monica. She's the Associate Director of Inner Garage. She'll introduce herself shortly. You can go to the next slide. So a little bit about Vera. We really are big lovers of data. We use data and research to drive evidence-based criminal justice reform. So like I said, we work with both what we call inside, outside, community advocates and folks in government to improve our systems of public safety. We have many, many different projects across the organization. We're a pretty large organization with 4 offices, with projects focused on policing, prosecution, victim services, etc. So we're in town this week meeting with folks. We'll meet with some of the folks at the CJCC. We met with the chief in Springdale this morning, and just getting to know folks and talking about what does policy and practice look like in this community. And so today we're going to be talking through some national and local trends. And it's a small group. We really want this to be conversational and a discussion on the outcomes of current Washington County practice and policy, so that we can really highlight some key opportunities for reform based on best practices and evidence-based reform. So that said, we're not from Washington County, we're not from Arkansas. You guys know your community best, and so we really want this to be a two-way conversation. Unfortunately, the data is quite limited currently in Washington County, which is why it's really, I'll make the case over and over for better data collection, so you can really monitor how policy and practice is driving the jail population. But today we're working with what we got, and I think it's still great to start off conversations. And also some of this stuff might be a little bit of a review for y'all. So if it's like, we all know that, because I don't know where everyone in the room is coming from. So if anything feels like, I know we have limited time, if anything's like, yeah, we know the bail statute in Arkansas, we can kind of move more quickly through that, okay? So first, I just want to back up a little bit and talk about what do we mean when we talk about mass incarceration, right? So many folks tend to really only think about prisons, right? Arkansas is actually, unfortunately, the 3rd highest incarcerator in the country. And so for us, it's really important to break that down and pay attention to the more than 600,000 people who are in local jails on a given day. That's just on a given day, but people will actually cycle in and out of a local jail more than 6 million times in a year. 6 million times. So we really, really believe that change can begin right at home. Local jails are managed and operated by locally elected and appointed officials. So that's why it's really important to make sure that we are closing that front door to mass incarceration, as we call it. Go to the next slide. A little known fact is that actually jail populations in big cities have been declining since the 90s, but unfortunately in smaller cities and rural counties, incarceration rates have been skyrocketing. We call this the quiet jail boom. We're seeing this across the country, where unfortunately over the last decade or so, small towns, small cities, much like Fayetteville and Washington County, have invested millions of their taxpayer resources into expanding the jail rather than address the policy and practice process that are fueling the growth in the jail population. And these are rates when we get to, so this is rate, which means that it's controlled for population growth. These are not just counts. Like I said, Arkansas has seen tremendous growth. This is actually now from last year, but Arkansas has seen the 7th highest increase in jail and prison population. So this past year was has become now the 3rd highest increase rate. And we unfortunately see this in Washington County as well. And I'm sure you're all very well aware of the overcrowding problem in the county jail. As you can see, since the 80s, the incarceration rate has grown by 423%. And again, that's per capita of the working age population, which is the population most likely to be interacting with the justice system. And so that's controlled for population growth. The pretrial jail population is now 22 times as high as what it was in the 80s. So, we like to say like jail populations are not like the weather, right? They don't just happen. These are the result of very clear practice and policy choices. And so today we're going to be getting into some of those, and they range across the justice system continuum to try to address this growth. And as you can see here in the early 2000s, when Washington County expanded the jail, the population skyrocketed. And we see this everywhere. We call it the field of dreams paradigm. So, if you build it, they will come, you will fill it. And unfortunately, we see this having occurred here in Washington County as well. We see large growth of pretrial numbers, especially. So a little bit about who's incarcerated in the Washington County jail. What are we talking about? Who are we looking at? So these are very top line, but Black people are incarcerated in Washington County at a rate 4 times that of white people. So while they make up roughly 4% of the general population in the county, they make up 19% of the county jail population. This might not be surprising to many of you in the room. We know that, unfortunately, every single stage of the justice system decision-making continuum, Black people are unfortunately treated more harshly. And so we will talk toward the end in our recommendations about how to try to pass policies that have that lens toward reducing those inequities. If we go to the next. We also, across the country, have seen the number of women in jails grow rapidly. And this has been really shouldered by small cities and rural communities. So in Washington County, the number of women in jail has increased 14-fold since 1983. And the reason I chose 1983, that was just the year that there was consistent data across many of these metrics. So anybody who has a loved one who has been incarcerated knows that a jail stint in jail affects more than just the person who is going to jail, right? 2 out of 3 women in jail are mothers to children under the age of 18. 1 in 2 of all people who are in jail because they couldn't pay their bail are parents to kids under the age of 18. And 1 in 2 adults in this country has had an immediate family member who has been in jail or prison, right? So it really does impact more than just the person going through. And actually, incarceration of a parent is considered one of the adverse childhood experiences, right? These are things that are known to cause developmental challenges for children. And it's very striking to me that this is one of the ones that the state actually, continues to inflict on a regular basis. And we put this up to start a conversation around what might be other ways to keep families together and to keep kids from having these traumatic experiences. So let's look a little bit more at just the booking information. So this is between July 2020 and July 2021. We can see that 20% of people who were booked into the Washington County Jail were booked 2 or more times, right? And this points to a real underlying problem, which is likely stemming from substance use or poverty. We'll get more into that shortly. But as you can see, we're seeing real jail, what we call jail churn. And I think an important thing here is to think about what actually works and how can we change our practice to keep people out for the long haul, right? So we're not seeing them come back through. We're not paying to detain them over and over when they maybe could be contributing to our communities, right? We also see in the length of stay data, this I find really interesting. So during that same period, July 2020 to July 2021, 42% of people who entered the jail were released within 3 days, right? And so that really begs the question to me is, how many of those folks didn't really need to be booked in the first place, right? Who could have been processed and then released rather than have to spend, up to a day to 3 days in jail. We know, as we'll talk about momentarily, that even just 2 days in jail is enough for somebody to lose housing, lose potentially custody of their children, and cause serious strain to relationships that could be really destabilizing. So in terms of, very low-hanging fruit, there's, folks who could be diverted out earlier so that they're not even taking up that 1 to 3 jail stay. And that would alleviate a lot of bed space in the jail. Just a little jail spending, and we'll talk a little bit more about this throughout the presentation, but it costs Washington County $97 per day to incarcerate somebody in the county jail, and that is around $35,405 on average per incarcerated person. That is quite a lot of money. I know I can think of a lot of things I would do with that much money. I want to talk a little bit more about cost, right? I know you are all considering a jail expansion, and we've worked with communities across the country who have also been considering jail expansion. Jail costs are typically if not the largest, one of the largest expenditures in a county's budget, especially for smaller places that are more strapped, right, for resources. Luckily, Washington County seems to be thriving. So nationally, jails spend about $25 billion per year. When we think about jail expansion, the initial capital costs of a jail expansion actually make up only 10% of what will ultimately be the cost of running and operating the jail. We also see, unfortunately, that expansion projects nearly always surpass what the original budget was quoted as, right? If you do a search in any county that has had a jail expansion project and look at their news coverage, you will see just over and over minutes from meetings showing that unfortunately they've had to approve another 10 million, another 4 million, another 8 million, right? And so just the costs in the original budget are not exactly what it ends up being. As I mentioned, we've seen that that's grown most rapidly in small communities. And what we're going to talk about shortly is just how this massive community investment, often at the cost of other things, doesn't really have the return. It doesn't have the return in terms of enhanced public safety. In fact, it actually has criminogenic effects because of how destabilizing it is for folks, that it ends up causing people to be more likely to engage in behaviors that are criminalized and therefore create future victims and victimhood. This is a quote just around the jail forecast. I know often when counties are considering a jail expansion, they bring in someone who conducts the study, and they typically give you a forecast for how many jail beds are needed. And this is a quote from an article in the Journal of Criminal Justice about how long-term forecasts are really flawed in their methodology, and instead we should use them to help. We should use past jail populations not to predict the future, but instead to tell us how particular decisions have impacted the growth in the jail population. Just to break down the population a little bit more, as you are all probably well aware, there are about 60 folks in your county jail at the time that this data was collected, which is now 2018, so this could be a little bit outdated for this one. Oh wait, this is 2020, I lied, I'm sorry, lots of numbers here. 2020, 60 folks held for federal authorities or the state DOC. And so we know, we've seen this across the country. This has become very popular, is counties trying to build bigger jails to get the per diem payments from the U.S. Marshals, from ICE, in order to, bring in some revenue, balance the budget, right? That's a very common reason that we see for expanding jails. Unfortunately, the reality is in a lot of these places is that they end up not being able to fill them, and taxpayers are left on the hook for that capital cost and for the continued operating costs of a outsized jail. In 2018, from the Washington County budget information, we were able to see that Washington County spent nearly 1.5 million on housing people for federal agencies and only received around 897,000 back. So that's actually running at a cost to the county, and presumably taxpayers had to make up that.
Do you have data for people who are incarcerated outside of Washington County, but just from other counties and other municipalities?
Yeah, so other counties who are renting beds in Washington County, you mean?
Yeah.
Yes, if you go back to the other slide, and it's also in the fact sheet that we have. One more back. Yeah, so other counties, it looks like at the point of data collection here, there were 15 folks for other counties. Yeah. You can go back forward. Thank you, Beth. So again, this might be some review for folks, but we know that jail incarceration is a symptom of social problems, right? Of really unmet needs like poverty, mental health, substance use. And during the pandemic, we saw a heroic effort in many places, including in Washington County, to seriously reduce the jail population, to say, like, who can we get out that doesn't really need to be here? And nationally, we saw that charges declined most steeply for port, driving, and drug offenses, right? And you might think, like, oh, okay, like those probably, with the exception of maybe drug offenses, those probably aren't that many offenses, right? But in reality, those actually accounted for 55% of book things prior to the pandemic. So I think to me, again, that points to a really clear opportunity, right, to ask the community, like, okay, how do we actually want to respond to these types of behaviors? Is it, putting somebody in jail and then potentially them not, we're going to get into bail shortly, but being stuck for weeks, months on a, court offense or whatever? These are questions for your community, right? So we know serious mental illness affects, a large portion of folks in jails across the country, including in Washington County. I'm sure you've all heard or witnessed yourself some really, really horrible crises that people are experiencing. And so again, policy needs to be responsive to that, to actually get at that root cause of the crime. Okay, so these are just most frequent charges. We can see that most charges were for things that are not actually a new crime. So non-criminal behaviors such as failure to appear, holds for other departments, role violations, possession of drug paraphernalia actually begins with that. There it is. So the question, almost half were for failure to pay fines and costs and violations, and then possession of drug paraphernalia made up 21%. So the question here again, like I just mentioned, is like, all right, how do we actually mitigate what's going on here? How do we change the underlying circumstance so that this doesn't keep happening? These people don't keep cycling in and out of jail. And it's just worthwhile to note that actually at the same time, unfortunately the status stops in 2019, the most serious charges of violent charges, more severe drug charges, or theft all declined over between 2015 and 2019. So again, this is, I think we kind of got into this, but we know that these jail stays, people come in already very vulnerable places, and they leave usually in worse off than when they came in. Like I said, it increases likelihood of future arrest. People have pressure to plead guilty, which then unfortunately, because they often want to get out back to their job, their community, unfortunately leads to consequences down the line. And we hear all the time, and it's almost counter to logic, but folks saying like, well, I want my loved one in jail so I know that they won't overdose, right? And the unfortunate reality is that people are much more vulnerable to overdosing after they leave jail because of their, the change in their tolerance. Okay, so when we talk about bail, and I'm gonna hand it over to Monica very shortly. Often people might think very low bond amounts that's a low bond amount, right? $500. But the reality is 90% of people detained before trial are way too poor to pay even that, right? And most in 2015 dollars, nationally, the median annual income was around $15,000 prior to incarceration, which is less than half of the median for the general population. So, you see that before there's that 73%, that's how many folks in Washington County are being held before trial. And, many of them likely are stemming from a real inability to pay an amount set on their case.
When you say 73% are held before trial, I don't want to split hairs here. What does it mean held? I mean, are you talking from arrest to disposition, or?
Yes, so we're talking, and this data comes from looking at the jail population. So what the jail reported as who in their jail was pre-trial versus sentenced versus held for federal. So that's the anybody between arrest and.
Well, I'm just wondering if it's 73% are held the entire time. Or,
no, so
okay.
Right, absolutely not. Absolutely not. Great question. It's 73% of the jail.
Of the jail is
yes.
pre-trial.
I need to actually correct that in the slide.
Okay.
Thank you.
I got you.
Thank you so much.
70% of the jail population.
It's
yes.
pre-trial.
Yes. Unfortunately, we don't have any court data to be able to tell the story of a bigger picture. So all of our information is from the bookings information. Okay. And lastly, I just want to highlight how this is just Springdale, obviously, it's a subset, but you can see how many folks were stuck in the jail by bond amount. And you can see that for $2,500, it's like basically the same as $25,000 and $50,000. So even things that are ostensibly a lower bond amount are to somebody who is really indigent, might as well be $50,000. And so now I'm going to hand it over to Monica, who is going to talk more about bail.
So Vera said, my name is Monica Smith. I'm the Associate Director of Incarceration at Vera Institute of Justice. And I just, for a little bit of background, I started off my career as a public defender in Kentucky and then down in Louisiana. So, and I just joined Vera in August. So I'm really happy to be here with y'all today. So all of you probably know this, but when a person is arrested, then a judge or a magistrate or judicial officer is giving you an option to just release the person. It's called releasing their own recognizance, set a term of release, which can be financial or non-financial. So that could be checking with a person or drug testing or things like that, or to detain an individual. And of course, they also have the option of releasing on some kind of financial release, which usually means cash bail or a surety bail, where a person puts up an amount of property and then lists as services of bail bondman, usually 2% of that to secure their freedom. Which goes to the next slide, please. Okay, and bail is covered by the U.S. Constitution, and everyone has a constitutional right to bail. And so the seminal case is Salerno's. And it just says liberty is the norm and detention prior to trial without trial is the carefully limited exception. And so that means that, it's up to judges and again magistrates to make these individualized tailored bail decisions based upon the circumstances of that person. In Arkansas, has kind of what we would say is the gold standard language for bail, which is that the judicial officer may release the defendant on his own personal recognizance or upon an order to appear, and then, or they may release them on some other condition of release. And then again, this is just kind of codifying that language in Salerno, is that basically says that money bail should be the last resort. The judge should say that they're setting money bail only after he determines that no other conditions will reasonably ensure the appearance of the defendant in court, because that is the purpose of bail, to ensure that the person will return to court. Oh yeah, you can't hear me. I'm sorry. And again, these are the types of bails available, or types of release pre-trial available to folks in Arkansas. Release under our recognizance, which is they just are given a court date and said to come back. An unsecured bond, again, this is like a person signs a promise to pay. Cash deposit, they have to pay 10% of the bond amount directly to the court. Cash or surety, this is what people think about when they engage services of a bail bondsman, and that person will pay 10% of the amount, and then in exchange uses their property or money. And then cash only is when the person must pay the full amount of the bail in cash, and that's very rare.
I had a question.
Yes.
You go back to the last slide. So if a judge determines that that person can't pay the full bail, do you have any data on how many people are released after they identify that they have financial hardship and they actually pay to be served? They actually can't pay.
I don't think we have any data specific to Washington County on how many people are paying surety bond, how many people are just paying cash 10%.
That's a hard number in
That would the
Arkansas.
prosecutor's office might.
The jail in their monthly reports, they note how many people are booked in and how many people are being released without having to post a bond. So you may check with the jail on those figures. And I don't have those figures. I know what we do. I know that, Judge Lindsay sets most of the bonds, and I know that, frequently there are
Yeah.
bonds of own recognizance, and I know what we do with working with the jail. But I don't have specific figures on that. The jail probably will.
Yeah, we can absolutely look into getting that. And I think, the question for you all is whether, often in many counties, we see that they really only do ROR and cash or surety, right? They don't use all the tools in the toolbox. And so I'm curious, practice here, if it's similar in terms of like.
It varies.
areas.
I mean, obviously, the judges determine if a bond's appropriate, what bond is set. We've had kind of a working agreement over the last couple of years between my office and the judges and the jail, where they're looking at individuals who can't make bond that we can release, and others, maybe the nonviolent people who have failed to appear. The jail has certain criteria they go through because they've got a monitoring system. So then they'll contact me and see if I'll authorize a felony site, which is the same thing as an OR, with the condition of a monitor, because the jail started their own monitoring system. So that's another thing that's being implemented. But I don't have hard numbers on those. in
That's
terms of-
really helpful though, just to hear that, because we're gonna get into some recommendations and it sounds like you're already implementing some, so
We're
Yeah.
we're working on it. I
that's
mean,
great. And I think we'll probably want to follow up
Sure.
with you after this to kind of talk more.
And I don't want to go into the weeds of the monitor, but is there a fee to the person or? is
No.
it- Oh, that's great.
No, it's the county has, what they started doing was paying an outside agency to use the monitors, and the county would pay that, and then they realized it was a lot cheaper for them to go out and start their own monitoring system. So the inmates are not being charged.
Yeah, so this slide just, this comes from the NCFC report that I'm sure you've all read. They have a different ranking system than the Washington County Sheriff's Office, but as you can see, whichever ranking you use, there is a massive, to me, this reads opportunity, massive opportunity here. We know FTAs are a problem. We need people to come to court when they, have a case in front of them. What actually works to get them to court? And we're going to get into some recommendations later, but huge percentage of folks in the jail are there because of an FTA. And so that, we got to do something that works to actually get them to appear, which we'll talk about.
So I think that when people think about failure to appear, people say like, oh, they just don't want to show up to court. But really, in practice, what we see is that there's 3 buckets of non-appearance. So the first one is true willful flight, which is very, I think that sounds loud. The first one is true willful flight, which is people literally making the conscious decision to not go to court when they know they should be in court. The second is non-appearance, which is usually what happens for most people. It's like, you know, you have a busy life, you just forget your court date, or you have something that comes up, maybe you're a caregiver for a loved one, a small child, an aging parent, and you know, you just forget your court date, or you have an emergency, or you don't have transportation to get back and forth to court, you don't make it. The third bucket is people who are facing perhaps court costs, fines, and fees. They know they can't pay those fees, and they have a fear that if they show up and they're not able to make a payment or something like that, then they just don't go to court because they feel they'll be, you know, detained after that. So there are some non-carceral methods that we have seen and non-monetary things that we have seen in other jurisdictions that have worked. So one of them is to remind people of court dates and make the documents more legible. So this is, you know, one system that we've seen is a text messaging system. It's been very cost effective for jurisdictions to implement. It can be as little as 50 cents per day or 50 cents per person for the life of the case. So it's just like with your dentist, you get a text message for a reminder. Another option that places have is to provide free accessible transportation to court, child care options at court, allow defense attorneys a reasonable window to produce their client before issuing a warrant. So some places have implemented, especially during COVID, kind of a warrant grace period, and that can vary between 24 to 48 hours to a whole week or 10 days, depending on the jurisdiction. And then also things that end the use of court-related fines and fees. Because what we can see is that people fail to pay their fines and fees, then they get another fine and fee for a late fee, and then it just snowballs out of control, and they can never really get on top of that court debt, which requires them to come back to court periodically, and again, it's more opportunities for failure to appear. In 2022, the failure to appear cost was approximately, so far this year has been approximately $15,000 in Washington County, or that's
Per individual, per person. So 15,000 times however many.
Okay, at a cost of $97 per person per day. And the average length of a stay for failure to appear in Washington County so far this year has been 160 days. So you can see that it's costing the county an immense amount of money for people who, don't really have the money in the first place.
And what would it look like maybe to fund a van or a bus that, goes to everyone who's on the docket that day and just picks them up, right? Like that might be much cheaper in the long run.
I have a question. I can ask why. So that was the cost to Washington County for the individual. What's the cost to the individuals?
Right.
That's almost immeasurable, right? Because
Right, that's
each
why
one
we're
back
looking,
and-
we're looking, but that's a nominal number.
Absolutely.
compared
The cost of lost work days,
to- Yeah,
employment and transportation, life, often unfortunately, people leave jail with a lot of physical, worse physical health and mental health. You can't capture that.
another piece that I'd like to talk about is capturing how many FTAs that we have during the pandemic that didn't have access to join virtually. And what does that look like? And what was the fee for that? Like, how do you help somebody that just didn't have the means to have a computer or Wi-Fi or be able to join? And what did we do to make sure that that wasn't an adverse impact to that family, that community?
And then also, I think, we're beginning to see some bounce back from this, but these, workforce shortages, employers just don't have people to work, to keep their doors open even. So that's another thing that we need to look at.
We have data on court fees and spiraling court fees.
We do have that, not in this presentation, but we would be happy to share it, and our emails will be at the end of this. So follow up. We're gonna kind of move.
Yeah, we're gonna go quick. And the other thing, just quick about court fees, is that most municipalities spend far more money on collection fees and paying collections agencies than they ever actually recover. So we'll be happy to provide you with that. For instance, these money bail is not necessary to ensure people return to court. In New Jersey, they release 93% of people charged with an offense without requiring payment of money bail. And the court rate has consistently been over 90%. Similarly, in Harris County, Texas, they implemented a pretrial reform in 2019, which resulted in 65% of those charged with a misdemeanor being released automatically prior to initial hearing, and their return to work, the court rates there have been 93%.
I have a question. Are
Yes,
the
sir.
people in New Jersey, as they are in Texas, alleged misdemeanor?
No. They're,
It doesn't say that.
yes, I'm sorry, they're across the board misdemeanor and felony defendants in New Jersey. Next slide, please. And we have found that it also pretrial detention does not promote public safety in a more meaningful way. So pretrial detention has been found to lead to an increase in rearrest and not a decrease. Specifically, a Kentucky study found that when people are detained for just 2 to 3 days, they are 40% more likely to be arrested for a new offense in the pretrial period than those released under 24 hours, because it goes back to what we were talking about, that disruptive effect.
Yeah.
It spins their lives into a spiral.
Yeah.
The longer people were held, the more likely they were likely to be subsequently rearrested. Those detained more than a month were 74% more likely to be rearrested than those who have been released within 24 hours. Similarly, a Pennsylvania study found that the imposition of money bail led to a 6 to 9% increase in the likelihood that a person would be rearrested. Yes. Jurisdictions that have been active reform have been able to retain high rates of public safety. So now New Jersey detains 5.7% of all people charged with an offense. Their jail population has dropped almost 50% since 2012. There's just over a 13% rearrest rate for indictable offenses and for disorderly offenses. However, the rate of rearrest for serious charges was only 0.4% in New Jersey, and the rearrest rate for serious gun charges was 0.3%. So they really see remarkable results. And then Kentucky has mandatory automatic release court rules for most misdemeanors since 2017. In 2020, that was extended to include non-violent or non-sexual or lower level felonies. And the rearrest rate stayed low, only increasing by 3%. So it was 8% in 2019, and it bumped up to 11% in 2020. And that's only 3% increase after the more charges were included.
And the violent rates very low.
Like, sorry, can you go back to like realize statement I was reading that?
Oh, yeah, sorry. And only 0.5% of those released were rearrested for a violent felony in Kentucky.
Thank you. I'm sorry, the last one, because they talked about the reduction, 12% in jail.
In the jail population.
That's what I was
That's a
trying to-
statewide reduction.
And it's interesting because Kentucky, more than any other state, incarcerates for their state Department of Correction. So that's why the pretrial reform, it really impacted 12%, which is a smaller number because so much of their job population is state.
Is Steve's.
Makes sense.
Sure.
Yeah, this is just more examples. Harris County, Texas.
And we'll be happy to share with you so you can get the data. So there have been some successful alternative approaches. One of them is a summons in lieu of arrest. And the Arkansas Rural Criminal Procedure actually gives officers this ability. And we spoke this morning with the chief in Springdale and said that he has this project, which gives law enforcement officers the option of giving a citation and a court date for a person to return instead of arresting them and booking them into the jail. Go to the next slide. There's also some, sorry, do you want to talk about the project?
Sure. Yeah, so this is just, I found it really, really telling, reading the report from NCSO, or NCSC, what's their?
National Center for State Court.
NCSC, thank you. Too many acronyms and numbers. Oh, it's literally right there. Okay, what I found so fascinating was how many law enforcement officers noted that, so many of the complaints that they're dealing with are folks who need services, not law enforcement, and that this is really actually impacting their ability to do their jobs, to keep the community safe, right? Because they're having to respond to all of these folks who are really in crisis. So there are a number of models, and we have a handout which you can explore across the spectrum, beginning with police-based responses to co-response models, all the way to non-law enforcement community response models. And you can take a look at that one picture. We'd be happy to talk more. We also, a sobering and detox center. This also came up in the NCSC report, which, law enforcement wanted to see more detox centers to take folks who are, DUIs or who are intoxicated so that they can sober up. And Oklahoma City is the model for the sobering center, and they've seen really, really positive results. Driver accountability program. This is to deal with traffic-related offenses, including DUIs. It's a non-carceral way it's a diversion model, and it's really effective. If you'll go to the next slide, you can see that it had a 78% reported change in people's attitude toward their reckless driving versus 39% for arrest and only 19% ticket. And as a former teacher of that program, I could say it was very, very effective. Alternative approaches. So this is diversion.
We've seen some success in Kentucky. They have a very robust vocational community and technical college program. They have like over 20 throughout the entire state. And so this is pretrial diversion. So what it means, people are diverted directly from arraignment or pre-arraignment to community-based substance use disorder treatment systems or educational diversion. And again, educational diversion models give the state and the communities really an opportunity to increase their workforce and to engage in meaningful workforce development, because we know that once people have felony convictions, that can prevent them from re-entering the workforce. And so this gives them an alternative to that. And then also, but with these models, the ones that are most successful also provide community-based support, such as childcare, technological assistance, and transportation to and from these services. Because we know that if you have to do a Zoom meeting, but you don't have an iPad, you don't have Wi-Fi, then that can be a big contributing factor as well. And again, this is what we're talking about: automatic pretrial release for a subset of charges. Those are usually non-violent felonies and misdemeanors in most cases. Pre-arraignment and representation review teams. This is when attorneys or community-based advocates will come together and meet the person, while they're waiting for arraignment, and they will create kind of a community-based reentry plan, and then engage the prosecutor's office and of course defense counsel to determine whether that would be, a good alternative instead of having cash bail set in that case. And then this is something that is kind of picking up steam, I think, across the country, is an automatic bond reduction review docket. So this is just an agreement usually between the prosecutors and the defense and the judge, of course. And what it is that they'll set weekly reviews and say, this week we're going to review everyone that's in custody, that has been in custody for 2 weeks, everyone that has been in custody for 3 weeks, and keep having these periodic reviews to see if community members can be engaged or family members can be engaged to get those folks out of the jail on ROR or some other conditions, because obviously they're unable to pay the bail at that point.
And just the last note is, we've seen really Knoxville, Tennessee actually just codified their COVID practice into permanent law around giving folks who have indigent status, who have who are eligible given the subset of charges, just $0, right? ROR them, and otherwise making these meaningful inquiries into ability to pay, and acknowledging that for some folks that might be $0.
Jail reduction is possible here, and these are the Washington County numbers. And so it decreased by 50% from 686 people in jail on March 16th to 343 people on May 1st of 2020. And so it can happen here. It's just a matter of will and people being creative to come together to really reduce the jail population and also to reduce the costs to the counties and taxpayers.
That was a lot. We talked to you a lot and we got really
Sorry, we went
fast.
very fast at the end.
We can open up for Q&A discussion. I don't know if folks are able to stay. We'd love to talk with you all. Just, I know you mentioned you've already doing a bond reduction review docket. So, I'd be so curious to hear how that is going and how, how is that going?
Well, it was going great at first in terms of number wise. We ran into issues. Fayetteville here. I mean,
Right.
I think, and we've got our criminal justice coordinating committee that we have been talking. A lot of the things that we need require funding.
Right.
And I've been a big proponent of pretrial services because I think Judge Lindsay, would agree with me that the biggest problems that we face are individuals who fail to appear for their court dates or who continue to get rearrested.
Right.
And so my thought is with pretrial services, that could put a dent in that, because if you have someone who is, we've got, the jail has a notification system right now. I don't want to say it's ineffective, but it's not as effective as hope, simply because when an individual gets booked in, they give a number, they give a cell phone number. That number often changes from,
Right.
and so that's the only number that they have. And so they're sending out a text message to a number that doesn't exist anymore, isn't appropriate. But nevertheless, they're still doing that. And
Right.
what we had talked about is, maybe a retired probation officer or something to kind of not necessarily supervise people, but keep track of them and try to find services for them, pretrial services such as, drug treatment, job training, balancing the checkbook.
A supervised release with voluntary referrals.
Yes.
We're calling them a diversionary case manager, and we're in the process of getting that.
Great. Well, we would really love to talk more with you guys about it and see what that actually does look like and how you can ensure that it is reaching the most people in the community. It sounds like a really good idea.
If we could get people to show up for trial,
Right.
and stop getting rearrested,
Right.
obviously you'd have fewer FTAs,
Right.
because you saw that
Absolutely.
there are a ton of FTAs in the jail, and it would speed up the process. And those people who are in jail, their cases would get processed sooner. Obviously they're going to be. I don't want to drag this on because I could go on for hours about this. But
We should meet another time because
Yeah.
we could also go on for hours, but I think what's underlying that, right, is any of these reforms that you do, you've got to have the scaffolding to support folks because most people are struggling. And so if you want to have the outcomes, the goals, which are public safety and appearance in court to, actually bring,
right.
you got to have the things that will get people there so you can do it. And maybe text messages is working for these 25%, but it's not working for the folks who have phones that are only run on Wi-Fi, right? Or whatever it is.
Well, another thing that was mentioned there is at the beginning of COVID, I sent out a memo.
Can you go to the next slide just so folks can get our emails?
I sent out an email to all law enforcement saying these are the types of situations, the types of offenses which I'm pre-authorizing felony citation.
That's great.
The problem we ran into was we were doing it roadside, and the officer on the scene wasn't getting the information he or she needed, such as criminal history and everything else, and it turned into people were getting released when they had 6 or 7 priors, they had a violent prior. So I had to nix the whole roadside thing, but kept it's still in effect for the jail. They get people that come in that they can automatically release on my authority.
Do you know if they're exercising that authority?
They are to a certain extent, but they're also getting a lot more people who are coming in with multiple open cases, and in which those situations it goes to judge's determination
Absolutely.
as to whether or not they.
And so for,
judge wants to set
some
a
of
bond.
these, right, bail is, like, the reality is, as we saw from all the data, that bail isn't actually needed to ensure appearance. And so a person can still go before the judge and the judge can say, listen, I want some conditions to help ensure you get to court. I want you to check in with the person once a week or once a month or whatever it is, based on, the Arkansas statute is really money bail, and in the way that it is in practice is detention bonds, right? Because people can't pay it, unfortunately, even if that's not the intention of the judge. I'm sure, often they don't intend them as detention bonds. So if it's not meant to be a detention bond, then what non-financial conditions of release will be enough and will be sufficient to ensure appearance and public safety? And how can the community be creative about that? Like you're saying. And so these recommendations, right? It's like bond reduction review doesn't just mean everybody automatically gets a bond reduction. It means that you're going to actually give folks a fair shake at a bond that they might be able to pay, right? And Vera actually created ability to pay calculator, which we'd be happy to share with you, that you put in for people, right? How much are they paying in rent? How much are they paying in child support? How much are they paying for diapers? Things like that. How much do they make? What's their income? And then it tells you how much they might meaningfully be able to pay for bond. And that's could be $21, right? It could be $7. And right, it just is a helpful way of really seeing based on people's actual financial status.
Well, if they would have a financial statement with them when they got arrested.
Right.
That would help, because I'm the first person that sets bail in Washington. Except on the weekends, we rotate some judges. And so I never have their financial.
Right.
At probable cause. So now, if they get arrested on Monday, by Wednesday, they're going to appear in front of the judge face to face. That's their first step to ask for the bond reduction. Maybe by then they gathered some information about it. And then if they're arraigned 30 days later, they're going to have another chance.
Right. Oh, so
to
arraignment,
file
right.
for a bond reduction. And then once they don't even have a case number until arraignment comes.
That's
And
30 days
so
after.
That's generally, 30 days after.
30 days after.
And then, anytime during their case, the dependency of their case, they are allowed to file for a bond reduction if they can show changed circumstances since the third time they had a shot at getting their bail.
And
So it's not just one decision.
Right. No, absolutely not.
And as Matt has said previously, I took over 75% of the criminal cases in January of 2015. Almost immediately, I was visited by the sheriff's office and said, hey, could you consider lowering some of the bonds, particularly the FTA bonds, which I did. And, ultimately it got to the point I said, look, when I set a bond, and all of our judges, I really believe, over and above what Matt does by authorizing citations, we're OR and everybody we can. But every time I sign failure to appear orders, there's a bunch of OR by Judge so-and-so, some of them have money.
Yeah.
And but when I set a bond, again, the rule of criminal procedure says to assure their appearance in court. And when a person has been arrested 6 or 7 or 8 or 9 or 10 or more times, which I see frequently, I'm not setting a low bond. I took an oath to abide by the Arkansas law. Right now, money bail is the law.
Right.
I can massage it a little bit, but I can't ignore it. So when I have someone who has beat up the same person 5 previous times, and they've done it again, they're gonna get a high to protect the victim in the case, particularly when it's been the same victim every time. And I do get that information when I set bail every day, Monday through Friday. But I'm just telling you, we're trying to do what we can to get people out of jail. We did have that initial success, but part of that release, I'm convinced, led to FTAs.
Right, and so that's, I think you're absolutely right. One, it's just, these are not easy problems to fix, and I think often people say like, oh, well, you just do text message reminders, it's all good. That's not true. It takes a multi-pronged approach, and that, and a real investment, I think, on the part of the community justice coordinating commission or council, the pretrial services, if you're able to invest in a really robust pretrial services, right, that attacks from all angles, right? I had this professor back in college. One day, a girl in our class just started smoking a cigarette, and everyone was like, what is happening? And then our professor was like, why did nobody ask Alice, like, why are you smoking? And we're all like, oh, and he's like, yeah, in policy, like, ask the people why they're not showing up, right? And then what, all of your policies should be responsive to what's actually driving the behavior. And so having those types of conversations with people to say like, okay, you is it because you can't get a ride? Is it because you have work and so maybe expanded court hours or an additional, additional day of court on a Saturday? I know, maybe you need more judges. Right, what are all of the reasons? And then those are policy question problems, right? To give you more resources, because you're right, we need people to show up for court. And so what can we do that actually is gonna get them there? That's not gonna cost the county, millions of dollars in annual operating costs, millions in, what's gonna be decades of potentially a municipal bond. And like you mentioned, the cost that's really immeasurable to the community.
One other thing that I'll add real quick, then I've got to go. One thing that we've started doing now is we have provided the jail with affidavits of indigency. So when a person is booked in, they used to fill that out at arraignment. Now they fill that out when they're booked in. And so the Judge Lindsay may not have their financial information when he's setting the bond, depending on when the person gets arrested. But the judge at their first appearance will have that information, and they're going to be appointed a public defender. And at that point, they're going to say, look at this, blah, blah, blah. My client is indigent, can't afford this, can't afford that, and ask for a bond reduction and whatnot. So depending on the charge.
That's great.
And depending on the charge, the judge may OR, the judge may reduce their bond. It's not unusual for the judge at the first appearance to reduce the bond.
Yeah, that's great. And it's, we're not trying to be like, oh, the judges are setting these bonds that are so, we know that you have a lot of considerations to make. I think what the real thing to underscore here, and I'd be curious if anyone's collecting data on the affidavit information, is to see whether since that change, the bond reductions, if people could now afford the bonds that, right, like how many folks then were able to access that, right? Bond's supposed to be a means to release. How many people are able to access that mechanism for release based on the reduction, or are folks getting stuck? And I'd be curious also to see that broken down by race and gender, because unfortunately we can see that, Black people and Black women especially are stuck in jail because of unaffordable money bond. And so, we say it all the time. We want to see that we love data. We are here to help analyze data. This is our bread and butter. And so to point to the pain points and what to improve, but also to show the real successes of the programs that you're implementing, to say like, we have done some good things. Here's what we need to expand or replicate elsewhere, right? So, we're here as a resource. There's our emails, and we'll definitely be reaching out to you because, we've been generously invited by the folks at AJRC who are, always reaching out for data analysis and support. And we work also with government actors as well. So thank you.
Okay. Yeah, I'm sorry. I've got to run.
I know.
Thank you.
Thank you.
Mhm.
Thank you.
Absolutely.
I can run my mouth a long time.
Oh, for a second, I just want to ask, does anybody on the Zoom have any questions? I'm gonna pause for a second in case you guys have one.
Well, and very few of our FTAs are just FTA, like they're either arrested on another charge and they have an FTA warrant out on them. But very few of them have only open FTA.
Right, well, in order to get an FTA, you would need to have an open case. to
No, I'm
arrest.
Okay, so I'm,
Yeah.
yes, however, I'm saying that they are not arrested because of their FTA.
She's saying that
They
they
get
are
arrested
arrested
for
for
something.
something.
Yeah,
else,
they
and
commit
there's
another
a
crime
warrant.
and then they
And I'm
have an
not gonna do
FTA.
that.
Accused of another
They're
crime.
allegedly
So,
they're
right,
arrested.
so they are arrested for something else.
Mhm.
And then they also have an
Right.
FTA for a
So this
previous arrest.
Really speaks to, my big ask is for transparent granular jail data, so, we
Well,
built
you
it.
can, and you can get that on the sheriff's website.
We've tried to get that. So if you have information about that, I would love to connect with you.
I
because
get it on the
we-
sheriff's website.
Great, let's look at it, because we'd love to be able to see by controlling charge, what's actually keeping folks in the jail. That would be able to paint a much more robust picture if you have that information, literally that's pure gold to us. So if you could share that, that would be like amazing.
It's literally on the sheriff's website. So you
Great.
just have to go in and look at.
There's my email, I'll send you a note, if I can get yours to follow up.
Absolutely, but I mean, I'm just saying, like, you just have to look at the individuals.
Oh, you're saying on the roster, so the issue with on the roster is that you can't actually see what the most severe charge is. So even though all the charges are listed there, you actually cannot see what the controlling charge is. So yes, we've tried that. And that's where a lot of this data comes from, that's why a lot of the data in here is most frequent bookings, because we can't actually, most frequent charges that are showing up in bookings, because we can't rank by the hierarchy, so it's limited, but yes, I do know the data that you're talking about.
One last pass, if anybody on Zoom had a question, I didn't see any. Okay, I think I'm wrapped up.
Thank you all so much. We're really available as a resource. Judge, other folks in this room, it's really great that you guys are coming out here to have this conversation, and it's a problem. This is not a Washington County problem. This is an everywhere problem.
But, and I'm assuming that you plan to talk to people with money.
Absolutely.
Yes.
Absolutely, we do, and I'm really excited tonight, we're talking to the Fayetteville CDAP, to say, like, what are the services in the community that actually help folks get to court, right? What are the things that are needed to ensure a more successful process? And so, yes, absolutely.
I just want to tell you one other thing, because you mentioned more judges. Until we get more prosecutors and public defenders, more judges
Absolutely.
are not going to.
I was just throwing that out as like what are all the options that maybe could be explored, right? Like, definitely, I'm not saying this is happening here. In other counties we've seen, it's been like, oh, actually the judge only comes into work 1 day a week, and we could speed up, case processing if the judge came to work more than once a week.
Well,
So just,
Problem is, I think Judge Taylor, who handles the other 25%, could spend more time in court. And that has been proven, but the problem is the outmanned public defender's office and prosecutor's office has to have some time out of the courtroom
Right.
to work on their cases,
absolutely.
which are beyond human.
Right. Monica was a
Yeah.
public defender.
They can't do it. They cannot do
It's
it.
not possible, humanly possible.
To
So,
that, I would like to say that Judge Lindsay came to the court. He spoke last year and told them that we needed more public defenders and more prosecutors. So they know that. And to the question about talking to people who have the money, we're talking to as many of those people who will talk to us.
Mhm.
and they did find some more prosecutors in public. The state has recently given some money to, it's not going to fund it for long, but hopefully
hopefully the reduction, you know, what I like to say is hopefully the reductions in the population that come as a result of implementing some of the reforms we're talking about will pay over and over for these positions for that, right? When folks have advocate counsel, they don't, you know, they shouldn't really be, if, you know, determined, you understand. Anyway, thank you all. And I really want to reiterate, like, we are here as a resource. We workshop policies with judges, with prosecutors. We workshop, you know, we're here. Thank you.
Thank you.
Yeah. Like, we're gonna get a spotlight.
Oh, I was gonna say.
Thank you. And tell me if you have any questions.